Why do states violate torture prohibition in IHL? Have you ever wondered why some countries still use torture, even when it is clearly banned by international law? This question is important as it touches on the very principles of human rights and dignity during armed conflicts. Let's break down the reasons behind this troubling issue. First, the prohibition of torture is firmly established in the Geneva Conventions of 1949 and their additional protocols. These laws classify torture as a grave breach and a war crime, applicable in both international and non-international armed conflicts. This means that torture is not allowed under any circumstances, even in times of war or unrest. However, states often violate this prohibition for several reasons. One major factor is the pressure for security and intelligence. In urgent situations, some governments justify the use of torture to quickly gather information. They may argue that this is necessary to protect national security or during counterterrorism operations. This mindset leads to the use of what they call enhanced interrogation techniques, which are essentially forms of torture. Another reason is the weak enforcement of laws against torture. While international law requires that torture be criminalized and punished, many states fail to investigate or hold accountable those who commit these acts. This lack of accountability can stem from political interests or a military culture that tolerates abusive practices. Some states also exploit ambiguities in the definitions of torture. They might claim that certain situations, like conflicts in occupied territories, do not apply to the torture prohibition. However, international bodies consistently reject these interpretations, reinforcing that the ban on torture is universal and absolute. In some cases, torture is part of systematic or widespread attacks against civilians. This can happen when it is state policy or when authorities tolerate such actions. These practices often reflected deeper issues of discrimination or political repression within those states. The chaotic nature of armed conflict also plays a role. In the heat of battle, legal norms can be disregarded. Combatants may act without fear of punishment, and command structures may fail to enforce compliance with international humanitarian law, especially in non-international conflicts where legal frameworks are less developed. From the perspective of international humanitarian law, including the Geneva Conventions, these violations are serious breaches of rules meant to protect individuals during war. The law sets minimum standards for humane treatment, explicitly forbidding torture and cruel or degrading treatment. To tackle these violations, there are practical steps that can be taken. Mandatory training for military and security personnel on the absolute prohibition of torture is essential. Additionally, states should explicitly criminalize torture in their domestic laws and ensure effective judicial mechanisms to investigate and prosecute offenders. International monitoring and reporting mechanisms can also help hold states accountable. Promoting a zero-tolerance policy within armed forces and security agencies is crucial to combating this issue. In summary, states violate the torture prohibition in international humanitarian law due to security pressures, weak enforcement, legal ambiguities, systemic practices, and operational challenges. Despite the clear and absolute nature of this prohibition, these factors contribute to ongoing violations.